everyone, and welcome to this short video. This is Jones Chase's A to Z of employment law, and today I am dealing with the letter S for settlement agreements. A settlement agreement is a legally binding contract which is made between an employee and their employer, generally entered into at the termination of employment to set out the full terms which have been agreed between the parties for an exit. It stops an employee or worker from bringing most claims in the future after they leave. Settlement agreements are binding in law and are recognised by statute as one of the ways to stop claims. Employees and workers are required to take independent legal advice on the terms of the settlement, usually by a solicitor, and the solicitor, or advisor as they're known, needs to certify the agreement to show that such advice has been given. Employers would usually agree to pay a contribution for the employees to receive that advice, which would be around £500 plus VAT. The employee is giving up their employment rights, so needs to take advice on this. The number one reason for why a settlement agreement would be offered is if the employment is coming to an end for a reason that is or may be difficult. Settlement agreements may be voluntarily offered by an employer to avoid drawn-out performance management, disciplinary or redundancy processes, all of which can be costly and very time-consuming from a management perspective and could potentially still lead to claims by the employee against the employer, regardless of how well the processes may have been managed. A settlement agreement can also be used where there is a dispute between the parties. The employee may be disputing the fact that they have been dismissed, or the dismissal was discriminatory, or as a result of the employee blowing the whistle. In all of those situations, the settlement terms can be negotiated against the threat of a legal claim, or one that has already been started by the employee. Settlements can also be reached while the employee remains in employment, for example, an equal pay claim or a claim for discrimination where the employee has not left the business. The main benefit of a settlement agreement is that it offers some certainty and a clean end to the matter in dispute. An employee cannot appeal a signed settlement, unlike an employment tribunal decision. The employee receives the security of a document which sets out the financial offer from their employer. They don't have to enter litigation to get payment for something that they feel was wrong, whilst the employer receives a guarantee that it will not have to deal with a future claim from the employee, and that if the employee does pursue a claim, which is highly unlikely anyway, the employer has recourse by way of a breach of contract claim. So what does a settlement agreement look like? Any settlement agreement being offered is marked without prejudice and subject to contract. This phrase is basically intended to mean that any communications relating to the agreement and the agreement itself cannot be admitted as evidence in any tribunal or court proceedings. So that includes any oral discussions, and it allows the parties to discuss termination arrangements more openly without the fear that such evidence would find its way to a tribunal if the proposed settlement was to break down. The employer is not admitting liability, and the employee has not accepted any payment until the whole thing is signed. The contents of a settlement agreement are at the discretion of the parties, except for those clauses which relate to the statutory requirements. For the majority of employees and employers, the most important aspect of the settlement agreement is likely to be the compensation being offered and the confidentiality clauses. When it comes to money, the first $30,000 of compensation over and above the employee's contractual entitlements such as notice and salary and bonus is known as the ex gratia payment and can be paid free of tax. These types of payments are often paired with a tax indemnity, which makes employees ultimately responsible for the payment of tax should HMRC determine that tax should have been deducted from the compensation. Other financial elements of a settlement include payments of salary and benefits up to the termination date, notice pay, statutory redundancy pay, bonus and commission payments, equity, pension, LTIPs, injury to feelings, the latter being for discrimination cases. In relation to confidentiality, these provisions are important as the employer will not want all other employees to know what has been agreed. This has to be thought through on a case-by-case basis, as there may be times when either party wants a piece of information to be private or public. Other non-financial elements of a settlement agreement usually include a waiver of claims, warranties from the employee, the return of property, confirmation that the employee has not accepted new employment, non-derogatory clauses, post-termination restrictions. If these are new, they will need to have a payment affiliated with them and that payment has to be taxed, and a carve-out for the making of protected disclosure for whistleblowing purposes. We regularly deal with the negotiation of settlement terms from both an employee and an employer's perspective, and we find that negotiations often hinge on three main things. One being the seniority and the pay of the employee, as higher earners tend to be offered higher and more complex financial packages. Two, the complexity and strength of any claim being pursued by the employee. And three, whether the employee is departing on amicable or acrimonious terms. This video contains general information only and is not intended to be legal advice. If you require assistance with the preparation of a settlement agreement, negotiations on an agreement, or advice on one you have been offered by your employer, please do not hesitate to contact us.